May it please the court. My name is Bill McCabe. I represent the claimant Frederick Clarke. In this case, we submit that I'll reserve 3 minutes for rebuttal. In this case, we submit the judge of compensation claims erred in denying this claimant temporary partial disability benefits after July 1st, 2014 on the grounds that he voluntarily limited his income. First, the claimant in these temporary partial disability cases, the claimant's got to establish a prima facie showing of entitlement to temporary partial disability benefits. This the claimant did. The claimant didn't reach maximum medical improvement from a physical standpoint until September of 2017. He had limitations and restrictions on him, basically of no lifting over 20 pounds and things like that. The claimant also established a causal connection between his restrictions and his loss of wages. He did that actually in 3 ways. Number one, he showed that the restrictions he had kept him from performing his former job with the employer, which was a fire and accident investigator and a bomb squad technician. In addition, the employer carrier basically acknowledged that his restrictions precluded him from performing prior work and contributed to wage loss in the fact that they paid him temporary partial disability benefits from March 24th, 2012 to June 30th, 2014. So this request for temporary partial disability benefits begins the day after he had already been paid temporary partial disability benefits up to June 30th, 2014. And finally, the judge of compensation claims clearly found that his injuries contributed to his wage loss because the basis of the denial was voluntary limitation of income following his loss of employment or when he left Mike's golf carts. So voluntary limitation of income is an affirmative defense. And that's what happens. Once the claimant has established a prima facie showing of entitlement to temporary partial disability benefits, then the burden shifts to the employer carrier to show one of those affirmative defenses, like voluntary limitation of income. Now, in this particular case, there's a statute, 440-15-7, that states that if a claimant leaves his job while receiving temporary partial disability benefits, then he continues to get the temporary partial disability benefits based on deemed earnings from that job. And that's what should have happened here.
Well, they cite the paren 6, the employee refuses income, and although the JCC didn't specifically cite that, I assume when he says that the claimant has voluntarily limited himself from working since he last worked at Mike's Golf Carts, I assume that's what the JCC was operating under. Why is this a paren 7, not a paren 6 case?
Well, first of all, he doesn't have to, the case law is pretty clear that a claimant does not have to undertake a good faith job search to get temporary partial disability benefits. There's more than one way of establishing a causal relationship between your lost wages and your injuries, and one of which is that you can't do your former job. Now, if you're talking about voluntary limitation of income and the claimant doesn't have to do a good faith job search, and the Alley case is directly on point, then how did claimant voluntarily limit his income? What job was offered to this claimant that he didn't accept? There's no showing for it. Now, they can argue perhaps that Mike Painter, the vocational counselor that was going to assist the claimant, maybe, and the claimant didn't cooperate with him, I guess, if you will. He didn't even come into the picture until January of 2017. So you have this period from July 1st, 2014 to January 2017 where there's no indication at all that any job was offered to this claimant that he refused.
Was the expert's opinion just forward-looking, or I thought it was broader? That it was this is someone who you know could work and could earn this income or whatnot. The expert, the vocational expert.
I'm sorry, the vocational expert's testimony.
Well, you were saying he didn't come into the picture until 2017. My question was his opinion just forward-looking, just from this day on he's fine, or was it a broader view that about what the claimant could or couldn't have done?
Well, he thought the claimant could do some work. I mean, I suppose arguably you could, relate that backwards. But the question here is, for a claimant to voluntarily limit his income when he doesn't have to undertake a good faith job search, so you can't say, well, he voluntarily limited his income because he didn't do a good faith job search, then the question comes, well, if he voluntarily limited his income, what job didn't he take? Well, if the vocational counselor didn't even come into effect until January of 2017, where he was trying to come up with some potential jobs for this claimant, how could he have not accepted a job prior to that? And another thing about this case, that the maximum number of temporary partial disability benefits that you can get is 260 weeks. Well, this claimant got temporary disability benefits back in 2004 for about, I don't know, I think it was about 42 weeks. The record doesn't spell this out, but it does say that he got temporary total disability. Let's see where it is here. From November 4th, 2003 to May 16th, 2004, and then they paid him temporary partial disability benefits from, it was March of 2012 to June 30th, 2014. So if you add up all those weeks, it comes out to be about 146 weeks, give or take. Well, if the maximum you can get is 260 weeks, that would leave about 114 weeks of temporary partial disability, which would end sometime in maybe August of 2016. So actually his eligibility for temporary partial disability would end before the vocational counselor even came into the picture.
Okay, Mr. McCabe, I'm going to move you on a little bit because you're...
Say again?
I'm going to move you on a little bit because
Okay,
you're getting
sure.
into your time, and I
Sure.
kind of want to hear a little bit on the permanent total. Seems to me your argument boils down on the permanent total to, well, the one doctor said, well, yeah, he can lift 20 pounds now, but anytime it can go down to 5. So therefore, Mr. Painter's evaluation is inappropriate. Is that pretty much your argument?
It's pretty much it. I mean, yes.
Okay, but there were other doctors that just had a 20-pound limitation, not 20 pounds that's going to bounce around. Why do we have to accept that one doctor's testimony?
Well, there's a couple reasons why I made that argument, really, is one is the judge misstated what Dr. Vargas said the restrictions were. The judge, in his opinion, says that Dr. Vargas said the restrictions are 20 pounds. But that's not what Dr. Vargas said. Dr. Vargas said it varies between 5 and 20 pounds, and I think that's pretty clear.
Okay, let's say we buy your argument that he mistakenly said something, and that, what would the remedy be at that point? To send it back for him to look at?
I think it probably would be to send it back and,
It wouldn't be to award permanent total.
Beg your pardon?
It wouldn't be to award permanent total.
I think it'd probably be remand on a reconsideration based on what Dr. Vargas actually said, between 5 and 20 pounds. And the other thing about Dr. Vargas, and I understand what you're saying, well, there's other doctors that said he had 20 pounds and so on and so forth. But Dr. Vargas was a physical rehabilitation doctor who has been treating this claimant since 2008. I mean, he's been treating the claimant for 9 years. He's also, him and Dr. Martinez, who the judge rejected his opinion, but they're the only two doctors that actually rendered an opinion on what this claimant's physical restrictions were after he reached physical maximum medical improvement on September 15th, 2017. So the judge misstated the restrictions imposed upon this claimant by a doctor who treated him for 9 years and who was the only one of only two doctors who rendered an opinion on his restrictions once he finally reached physical maximum medical
Well,
improvement.
the other docs, didn't some of the other doctors talk about an earlier date of MMI?
They did, but the judge in the orders finds that he reached physical maximum medical improvement on September 15th, 2017. And then their vocational counselor, and I quoted the part in my brief, but he basically says that if it's like if the restrictions vary back and forth and this kind of thing, I'm not sure what work this claimant could do. So that's why I think that the judge erred on the PTD issue.
Well, even as it relates to just Dr. Vargas and not counting Dr. Maniscalco, didn't Vargas say 5 pounds and then he went to 20 pounds?
Yeah.
So the JCC could reject the 5 and say, okay, well, I'll take the last statement of 20 then, right?
Well, the problem with that is in July of 2017, Dr. Vargas says 5 pounds. And then in his deposition in September 18th, 2017, which is 2 months later, says 20 pounds. So they said, well, you just said 5 pounds 2 months ago. What's the difference? He says, well, he improved. And they go, well, and so the claimant's attorneys ask him, well, can it vary? Can it go back and forth? He said, yes, it can go back and forth. Can this be frequent? Yes, it can be frequent. So he didn't, I mean, it was 20 pounds perhaps on the day of his deposition, but as he said, it can go back and forth. And it depends on, you know, what the claimant does, whether he re-injures himself or he overdoes himself or something like that. So I think his testimony is pretty clear that it's not a 20-pound limitation, that it vacillates somewhere between 5 and 20 pounds, and you don't know, it can happen frequently.
You know, that's interesting, though, because, you know, you use the term "it could." It would seem that, you know, if the doctor gives an opinion, I give him 5-pound restriction because I don't want to limit him lifting more than 5 pounds, you know, that would arguably be a slam dunk for you, but this, I mean, he's at 20 now, but, and I'm not sure it could go down. If that's sufficient to overturn the JCC's decision here?
I think it is. I mean, because it's not like he's not speculating or anything else. He's saying, yeah, it can change frequently. It could happen. He obviously doesn't know how often it's going to happen, but it could happen frequently. Thank you.
Good morning. My name is Allison McIndale, and I represent the employer carrier below, the State of Florida Department of Financial Services and its Division of Risk Management, the appellees herein. Your Honors, this case is a very simple case. The main issue in this case is whether competent substantial evidence supports the judge's decisions below. Appellant concedes that competent substantial evidence is the proper standard of review here, but appellant makes no arguments as to why or how he feels the judge's findings were not supported by competent substantial evidence. Appellant is simply re-arguing points of fact and law that the judge rejected below. It is not the role of this court to retry the case and substitute its judgment for that of the judge of compensation claims. Yet this is exactly what appellant is asking you to do. With regard to the temporary partial disability benefits issue, there was competent substantial evidence to support the judge's denial of temporary partial disability benefits on the grounds of voluntary limitation of income. We would concede that the appellate met its initial burden of proving that he was not at overall MMI for the period in question and that he had work restrictions that were causally connected to the industrial accident. That is true. And therefore, under the Toscano case, that would be a prima facie case for temporary partial disability benefits. We agree. We would also agree that once the industrial injury, or once established that the industrial injury and the resulting work restrictions remain the cause of the wage loss unless or until an intervening or superseding cause of loss of earnings was demonstrated by the employer carrier. That's what happened in this case.
Okay, let's assume that we buy off that it was not an appropriate reason for him to leave the job at the golf cart place. Why shouldn't Mr. McCabe's argument be, okay, what you do at that point is you determine those deemed earnings, but you don't totally cut off permanent total, temporary partial benefits?
Well, Your Honor, Florida Statute Section 440.15, subsection 7 is really not applicable to this case, and that's why the judge of compensation claims did not address it. Deemed earnings go to how you calculate temporary partial disability benefits, or the amount of temporary partial disability benefits due and owing. Deemed earnings are not a factor in determining entitlement to temporary partial disability benefits. And Judge Wetherell pointed this out in his concurrence in the Alley versus Crum staffing case. Appellant alleges that TPD benefits are due because earnings should be deemed under 440.15, subsection 7, but you don't even get there because he is not entitled to temporary partial disability benefits in the first place.
You had been paying out the temporary partial benefits.
Well, that's true to a
So
certain
isn't that
degree.
pretty much a concession that he would have been, he had restrictions that would entitle him to TPD benefits unless his earnings above a certain amount?
We would need to clarify that payment of temporary partial disability benefits. It was not a situation where the carrier was paying biweekly benefits from March of 2012 through July of 2014. In the record, at page 104, you will find an employer-carrier payout ledger, and a single lump sum payment of $7,500 was paid on July 2nd, 2014, in compromise on litigation that was pending at the time, to cover the period of March 2012 to June of 2014. So it wasn't a biweekly payment for over 2 years of temporary partial disability benefits. But the fact that that payment was made doesn't really have bearing on the current issues. He was working at the time. He was working for Sunland Distributors. He was working for Mike's Golf
Well,
Course.
you're arguing that there's various breaks in the causal connection. You know, he left DFAS and went to USAA, then he, private investigator, then Sunland, then Mike's Golf. But the JCC didn't find that, though. He didn't say there's been a break in the causal connection, therefore there's not an entitlement to disability benefits. His argument that I mentioned to Mr. McCabe, or his finding, was claimant has voluntarily limited himself from working. So, I mean, you're making what seems to me to be kind of a tipsy coachman argument, but we don't have that finding from the JCC.
Well, the difference was, in following up on what Judge Wolf just said, he was working at the time that those benefits were paid. He was working for Mike's Golf Carts. So he was not voluntarily limiting his income at that time. However, going back to the voluntary limitation of income, the burden did shift to the employer carrier. You're absolutely right to show that there was refusal of work or voluntary limitation of income. And the judge had lots of evidence on which to base that. He found that the claimant had numerous unrelated medical conditions that contributed to his refusal to look for work, unwillingness to look for work, or inability to look for work. Subjective excuses for not looking for work or not even working that were completely unsubstantiated by any medical opinion put forth by an authorized treating doctor. He was afraid of losing his Social Security disability benefits. He failed to comply with reemployment services that were eventually offered by the employer carrier. And the claimant admitted himself multiple times throughout the record that he had absolutely no intention of working or even looking for work within his restrictions. And
Well, let me ask you about that, give you kind of a hypothetical. Say I'm employed and I'm making enough that I would get, disabled on the job, make enough that I would get the full temporary benefits then. And then there's a job that I can do that's some minimum wage job that for whatever reason I feel is beneath my dignity, or I don't want to do it, or it's just not worth making $8 an hour to do that. Can't I choose to refuse to do that and then get the offset under paren 7? And that's just kind of the limitation that I've put on my income. I've taken that by not doing that work.
it would depend on whether the judge of compensation claims found the refusal to be appropriate or justifiable. And in this particular case,
Well, that justifiable, that's 6, right? That's the Employ Bridge case that I have some familiarity with, that you cite. That's a paren 6 that refuses employment, as opposed to leaves employment. And I guess my hypothetical probably would have been more of a 6 than a 7. But if I left a minimum wage job, deciding that I didn't want to do it for whatever reason, like apparently he did with Mike's golf cart going up to tend to his family when his dad died, doesn't that make it under 7 instead of 6?
no, Your Honor, it doesn't. It is more like a situation where, well, an Employ Bridge, that claimant was unwilling to commute, to make such a long commute to accept the job that that employer had available to them.
Well, and isn't that the difference? That here, there's not, the employer didn't say, come back to DFAS, we have a night manager, or night watchman job. It fulfills all the requirements of your physicians and the limitations. You make $10 an hour. This job is for you. Come on back to work with us.
Well, in the Toscano case, they reiterate this court's holding in Moore versus Service Master Commercial Services that stated that although an employer is not required to continually reoffer a job to avail itself of statutory defenses, the employer must establish continued availability of a job for each applicable period to obtain the continued benefit of the defense. In this case, the employer carrier showed that but for the claimant's voluntary decision to retire from the state of Florida in 2006 to accept a job at USAA that he was already in the process of pursuing at the time that he decided to retire, his employment with the state would have continued. He was working a permanent light-duty job at the time that he retired. That was purely voluntary on his part, and then he continued to work for USAA for another 2 years until he was terminated for violating company policy. So the employer carrier below proved that there would have been work available to the claimant with the state of Florida, but for his voluntary decision to retire. Additionally, later on, the claimant refused to participate in job search and reemployment services offered by Mr. Painter in this case. Refused to follow through with finding a security guard license or obtaining a security guard license, refused job leads, and has testified more than once in this case that he had absolutely no intention of looking for work or working at all. If that isn't voluntary limitation of income, I don't know what is.
So what would the argument be if he'd never left the golf cart place?
Yeah, it is very possible he could have continued to have been eligible for temporary partial disability benefits if he had remained at Mike's Golf Carts. But the fact of the matter is, he did not
So he would have
remain.
gotten the difference between what he was earning and the average weekly wage if he had stayed there?
If he was still working at Mike's Golf Carts, he would not have been voluntarily limiting his income.
But he would have received the delta, the same thing that he's seeking now, right?
It would have gone to a calculation of the amount of temporary partial disability benefits owed versus
They would have taken
entitlement.
that average weekly wage and then whatever calculation they do, and then subtracted what he was earning from the golf cart place.
It is possible if he had continued working and did not voluntarily limit his income. That's true. In this case, the claimant also had the responsibility, once the employer carrier met its burden of proving voluntary limitation of income, the claimant could have shown something additional through subsequent events that his continued unemployment and the injury was caused by the industrial accident. And if he's unable to make such a showing, then the unrelated dismissal remains the cause of the lost wages. In this
Can I
case,
ask
the
you
claimant failed
something
to meet that
about
burden.
can I ask you something about the JCC's order? He goes over kind of a recitation of facts and then makes some findings, and then he says, based on these factors and others not mentioned. How do we analyze other factors not mentioned in an order in determining what findings he used, whether there was CSE to support those findings? I mean, isn't that kind of per se reversible error to say, I'm not going to tell you what these other things are, but I relied on them, so good luck figuring it out?
Yes. The judge's order must be upheld if competent substantial evidence supports the decision. And the judge in this case outlined all of the reasons why, I assume you're referring to temporary partial disability benefits or with regard to permanent.
He says that in the TPD benefits,
Okay.
correct.
And the judge did outline in his order and in his findings of facts all the various reasons why the claimant didn't look for work or did not work at all in the period of time in question. And as I mentioned earlier, it was due to the numerous unrelated medical conditions. He had abdominal surgery in 2017, subjective excuses for not looking for work. He testified repeatedly that he didn't look for work because he was afraid of losing his Social Security disability benefits. His state retirement also kicked in 2016, I believe. He was worried about affecting that as well. He was admitted repeatedly, and it's the role of the judge to resolve any conflicts in that testimony. And in this case, the judge did resolve that conflict to find that the claimant had absolutely no intention of looking for work or working whatsoever.
Okay, but Mr. McCabe mentions, we used to go through all these job search acrobatics, no longer required to do that. And he's basically saying at that point, since you're no longer required to do a job search, it's your burden to show that there were in fact jobs available to him or that he was offered the job. How do you respond to that?
I don't think that it's a shift of burden back and forth like that. I think that once the employer carrier has met its burden of proving that the claimant voluntarily limited his income, the burden only shifts back to the claimant to prove that his continued unemployment is associated with the work injury. And the judge in this case found that it was not, that it was due to all of those other factors that the judge found were the reasons why he voluntarily limited his income. The claimant put on no evidence whatsoever whether a job search or not, and I agree, a job search is not absolutely required, that's true, but it's just one of those ways that you can show something additional that to
I understand it, but
reestablish
it
the
really
causal
seems
relationship.
somewhat inconsistent to me with the idea they would have been entitled to some level of temporary benefits while he was working for Mike's Golf Carts. You know, at that point, it was still, the injury was causing the restrictions. What at that point changed to show the injury still was not causing the same restriction?
What changed are the factors that the judge outlined in his order, that he had unrelated medical conditions that kept him from working, that he was afraid to lose his Social Security disability work, that he testified, the claimant admitted he had no desire to work, he had no intention of working, and no intention to look for work after he left Mike's Golf Carts.
Can we jump you ahead to two with your time left? What's the best CSE that supports the JCC finding on two? What's your best information that you have that supports it?
On permanent total
On the
disability
permanent,
benefits?
correct.
Yeah, appellant makes much of this argument that Dr. Vargas testified that the claimant had a 5-pound lifting restriction. And today here, appellant argued that there is no record evidence that Dr. Vargas said that he was restricted to lifting 20 pounds, but that's not accurate. There is record evidence at pages 1054, 1065, 1066, and 1071. Dr. Vargas testified that the claimant had a 20-pound lifting restriction. The judge of compensation claims has the ability to reject in whole or in part even uncontroverted testimony he believes, and Dr. Vargas stood alone with that 5-pound lifting restriction. Every single other authorized doctor in this case testified the claimant could lift between 20 and 25 pounds. The judge did not ignore it or overlook it. The judge made reference to it both at the trial and in his order. The evidence on which the appellant wants this court to substitute his judgment of that of the judge is speculative and does not amount to competent substantial evidence. Dr. Vargas uses words like if, could, it depends, if an injury happened, if he overdid it. That's all speculative. And there have been a line of district cases, including a workers' compensation case, that found that speculative evidence is
Let's
not
pick Dr.
constitutional evidence.
Vargas aside. Let's say we buy off on Mr. McCabe's argument that, you know, it's 20 to 5. What other evidence supports the JCC's finding here that there wasn't permanent total disability? I'm talking about the other doctors.
Well, almost every single authorized treating doctor that ever treated this gentleman opined that he could lift up to 25 pounds, or Dr. Vargas said 20 pounds.
What, okay, and I'm control of the clock, so I'm gonna let you go on. Basically, I think Mr. McCabe is arguing that was either stale or can't be competent evidence because it was not based on, at the time of MMI. How do you respond to that?
Well, to believe that would be to argue that the claimant was essentially worse and more restricted now than when the surgeons placed him at MMI as early as 2005. And there is no record evidence that he is worse. Dr. Vargas testified that he was stable. The injury is now over 15 years old. This claimant had surgery over 15 years ago. It does not comport with logic or reason to say that the claimant is worse now than he was when all the other authorized doctors placed him at MMI and imposed permanent work restrictions of no lifting between 20 and 25 pounds. Dr. Vargas never addressed work status in any of his narrative reports or his DWC-25 forms throughout the
I
years
think I
of his care.
understand your argument. Unless the other judges want you to go on, you're about a minute and a half over. Okay, thank you.
Thank you very much.
Thank you. She just stated, well, not just, but during her argument, that the claimant was not voluntarily limiting his income when he was working at Mike's Golf Carts. And the judge really made the same finding, because the judge says the claimant has voluntarily limited himself from working since he last worked for Mike's Golf Carts in July 2014. So there's an acknowledgement and a finding that the claimant's compensable injuries restricted his ability to work to $100 a week, because that's what he was making at Mike's Golf Carts. Now, how did he voluntarily limit his income after that? Well, he couldn't go back to work. They didn't have the job for him. So, yeah, he doesn't get that $100 per week anymore. So that's why Section 7 comes into play. he can still get the temporary partial disability, but it's based on his deemed earnings. She said he would keep getting them probably if he kept working at Mike's Golf Carts. Now, for the voluntary limitation of income defense, the statute says, if an injured employee refuses employment suitable to the capacity thereof, offered or procured thereafter. What job was offered to this claimant after he left Mike's Golf Carts that he didn't take? There isn't any. And it brings us to the Wyeth case, where this court said the employer carrier neither introduced evidence of a job offered or procured for claimant, nor otherwise established a quantifiable earning capacity by which the JCC could reduce the TPD benefits otherwise payable during claimant's temporary recuperation from her injuries. Accordingly, the JCC did not err in rejecting the ESA's voluntary limitation of income defense in this regard. I think the specially concurring opinion of Dr. Weatherall in Alley nails this case right in the back. He says, in this case, the claimant's wage loss.
I gotta stop you. Dr. Weatherall?
Did I call him Dr. Weatherall? Sorry.
Go ahead, I'm sorry.
Anyhow, he says, the extent of his partial disability is comprised of two distinct components. One, the reduction in his wages resulting from the light duty restrictions upon his return to work, which everybody is agreeing, and the judge really found, is $100 a week. And then the second one is the loss of the remainder of his wages upon the termination of employment for cause. And the judge went on to state that claimant established a requisite causal connection between his initial wage reduction and the compensable injury, thereby entitling him to TPD benefits in some amount. Now, if this claimant wanted to try to claim that he was entitled to temporary partial disability benefits based on zero earnings, then he would have had to have gone and done a job search or something to establish proof of further loss. He didn't do that, but he still should get his temporary partial disability benefits based on the deemed earnings pursuant to Section 7. Thank you.
Okay, the last case on our docket is Beth Hicks versus State of Florida.